Hi, it's Nathan Charles, and welcome back to the Rule of Law Brief. I'm going to start off tonight by saying something that's going to sound provocative, but I promise you it's not meant to be. My New Year's resolution is that I'm going to report more of my colleagues to disciplinary counsel for violating the rules of professional conduct. That's not a joke. That's not hyperbole. And it's not about personal animus, politics, or settling some kind of score. It's about professional responsibility and protecting democracy. I believe firmly that one of the most underappreciated reasons that the rule of law is in retreat in the United States is the anemic enforcement of attorney ethics. And I believe that lawyers themselves bear the primary responsibility for that failure. All right, so what are attorney ethics? Every state in the United States has a set of rules of professional conduct that govern who may practice law and how they may practice law. The rules are not aspirational. They are not guidelines. They are binding and enforceable. And in fact, adhering to those standards is a condition of maintaining the laws. While each state's rules may be a little different, they are overwhelmingly based on the American Bar Association's model rules of professional conduct. Those model rules provide a general baseline for what lawyer ethics are supposed to look like in this country. Every lawyer learns these rules. Every lawyer is tested on them. In almost every state, new attorneys are required to pass a separate ethics exam before they are admitted to practice law, in addition to the bar exam. So right from the get-go, let's dispense with the fiction that this is unfamiliar territory. Now, there are some of these rules that are arcane and complex. Now, that is true. There are edge cases. There are some gray areas. There are judgment calls. And for that matter, not everybody interprets the rules of professional conduct the same. But here's the part that matters, and the part that too many lawyers pretend not to understand. The rules that are violated the most frequently and enforced the least frequently are not the complicated. They're the simple ones, the common sense ones, the ones that every lawyer should understand intuitively. You cannot lie to the courts. You cannot lie to the courts about what the law is or what the facts of the case are. You cannot file frivolous pleadings to harass or delay the resolution of the case. You cannot engage in cases where you have a conflict of interest. You cannot abuse the discovery process. And you cannot use the legal process as a weapon rather than a tool for adjudicating differences of opinion. None of this requires a law review article to decode, not even close. Every lawyer knows when they are doing this. And unfortunately, they are doing it far too frequently. And despite that fact, meaningful discipline for attorneys is incredibly rare. Bar counsel offices are underfunded. Complaints are routinely dismissed without investigation. Investigations that are taken seriously may take years, and sanctions, when they do occur, are often incredibly minor and imposed long after the damage has already been done. Even worse, the legal profession has developed a culture that actively discourages reporting misconduct. Lawyers are told explicitly and implicitly that filing an ethics complaint is unprofessional, disloyal, or somehow inappropriate. What is often called professional courtesy is in practice frequently just cowardice. And this matters beyond the bounds of the legal profession. This is not merely a professional housekeeping issue. It is a matter of protecting democracy. There is broad agreement among serious political scientists that the survival of democracy depends on the perceived legitimacy of institutions. That is not even a controversial view at this point. In her really excellent book, Democracy: Stories from a Long Road to Freedom, Condoleezza Rice made this point very clearly. Her argument is not partisan, nor is it ideological. It is institutional. Democracies endure when people believe institutions are governed by rules, applied fairly, and enforced consistency. Now, courts of law sit at the center of that legitimacy. Democracy does not survive if people cannot get a fair shake from the courts. In fact, it doesn't even survive if people believe they won't get a fair shake from the courts. And people definitely cannot get a fair shake from the courts when lawyers cheat and get away with it. That is not subtle or profound insight. In fact, this is common sense. Courts rely on lawyers. Judges rely on lawyers. The adversarial legal system assumes good faith advocacy. When attorneys lie, manipulate the process, or violate basic ethics rules with impunity, the legitimacy of the courts erodes. When the legitimacy of the courts erodes, the legitimacy of the entire rule of law system in the United States begins to erode as well. So my New Year's resolution is rather simple. When I see clear, serious violations of the rules of professional conduct, and I see them far too frequently, I am going to report them to bar counsel more, not less. This is not about weaponizing ethics complaints. This is not about filing grievances over tactical disagreement or personality conflicts. This is about obvious misconduct that undermines the integrity of the legal system. And I'm saying this publicly for a very good reason. If lawyers will not enforce the rules that govern our own profession, no one else will. And if we refuse to do so, we should not be surprised when public confidence in the legal system collapses and democracy collapses with it. If the rule of law is going to survive, lawyers have to take responsibility for maintaining it. That starts with enforcing the rules that we already have. That is my New Year's resolution. And again, this is not about grievance. This is about preserving democracy, preserving the rule of law. It is absolutely essential to the future of our republic.